and if left unchecked, runs the risk of threatening not only regional but also global peace and security. I would like to emphasize once again that Turkey strongly and clearly rejects and condemns all attacks against civilians. Civilians must be protected at all times and under any circumstances. Since October 7, more than 30,000 Palestinians have been killed so far in Israel's indiscriminate attacks on Gaza. Most of them are women and children. 2.3 million civilians have been placed under full blockade by Israel, depriving them of their basic needs to survive, such as water, food, medicine, fuel, and electricity. Hospitals, refugee camps, schools, places of worship, churches, and mosques have been targeted unsparingly. Around 2 million Palestinians have been forcibly displaced. Israel's attacks have turned into collective punishment. In the West Bank, 400 Palestinians have been killed by either Israeli settlers or security forces in the past 4 months. As a matter of fact, 2023 has been the most violent year in illegal settler terrorism and violence against the native Palestinians in the West Bank. Representatives of relevant UN agencies, as well as UN Human Rights Council special rapporteurs and mandate holders have published various reports so far on violations of inalienable rights of the Palestinian people by Israel. The current trajectory risks a broader regional conflagration as well as intercommunal polarization. Furthermore, rising threats of Islamophobia, anti-Semitism, and extremism all around the world must also be taken into consideration. As the injustices and the double standards that the Palestinians have been subjected to for decades continue, the reaction from the peoples of the region and beyond will only multiply. In other words, we must hold accountable before the law those responsible for their attacks on civilians. Otherwise, such outrageous behavior might be emulated elsewhere in the future. Therefore, reinstating the rule-based international system is a must. In view of the foregoing arguments and recalling the relevant resolutions of the UN General Assembly and Security Council, the Republic of Turkey respectfully calls upon the International Court of Justice to declare the policies and practices of Israel in the occupied Palestinian territories, including East Jerusalem, illegal under the international law. Israel must also respect the historical status quo in the holy places in Jerusalem. Again, it is ever more important as we approach the holy month of Ramadan this year, while the Israeli attacks in Gaza and the West Bank continue. It is alarming to see reports regarding plans by the Israeli government to limit the prayers of the Muslims on Haram al-Sharif during Ramadan. The provocative rhetoric by certain Israeli ministers is also worrisome. Therefore, those who have conscience and morality must step in without delay. The Republic of Turkey will continue its efforts to contribute to the permanent peace between Israel and Palestine, more urgently for a lasting ceasefire in Gaza and immediate unhindered flow of humanitarian assistance into Gaza. Drawing lessons from past experiences, Turkey has also been developing the idea of a guarantee mechanism so that future negotiations could be held in a sound environment, and once achieved, a final settlement would hold for decades to come. The Israeli-Palestinian conflict has been at the top of the agenda of both UN General Assembly and the Security Council almost since the foundation of the UN. The UN, with its organs, following its primary responsibility of international peace and security, has adopted dozens of resolutions in relation to this conflict. It is crucial that the Court issues an advisory opinion in response to the questions in the resolution adopted by the UN General Assembly. The Republic of Turkey reiterates its firm support to a negotiated two-state solution based on the UN resolutions, thus the establishment of an independent, sovereign and contiguous state of Palestine on the pre-5th June 1967 lines, with East Jerusalem as its capital. Mr. President, distinguished members, not to repeat the previous speakers, we focused on specific subjects here. But after listening to the previous speakers in previous days, we are of the opinion that there is solid and efficient legal framework to declare the Israeli practices illegal and to contribute to this peace. Thank you very much.
I thank the delegation of Turkey for its presentation. I invite the next participating delegation, Zambia, to address the court, and I call upon Mr. Marshal Mubambe Mushende to take the floor.
Mr. President, Justice Nawaf Salam, distinguished members of the court, as you have mentioned correctly, Your Lordship, my names are Marshal Mubambe Mujende, State Counsel, and I'm the Solicitor General for the Republic of Zambia. I have come with my team, which includes His Excellency Mr. Sylvester Mundanda, who is the Ambassador of Zambia to the Benelux countries, which includes Belgium, Netherlands, and the Luxembourg. I also have with me the team that is on record with you. Allow me to proceed. Your Lordship, I have the honor and privilege to make a submission on behalf of the Republic of Zambia on the request for an advisory opinion of this court concerning the legal consequences arising from the ongoing violation by Israel of the right of the Palestinian people to self-determination from its prolonged occupation, settlement, and annexation of the Palestinian territory occupied since 1967, including measures aimed at altering the demographic composition, character, and status of the holy city of Jerusalem, and from its alleged adoption of related discriminatory legislation and measures. My delegation appears before this court as Zambia's unwavering commitment to peace and the principles of international law, which underpin the international system. We recognize the humanity and dignity of all individuals affected by the conflict, irrespective of their nationality or ethnicity. Mr. President, the Republic of Zambia did submit its written statement to the court in July of 2023, and we shall rely on the same. With leave of court, however, allow me to augment with oral submissions which are in support of the written submissions alluded to. Mr. President, we have carefully looked at the question that has been posed to the court, and we submit at the very outset that the Republic of Zambia recognizes the court's jurisdiction to render advisory opinions in accordance with Article 65 of the United Nations Statute. as it did in the advisory opinion on the legal consequences of the construction of a wall in the occupied Palestinian territory in 2004. We, however, make the case that the question posed to the court this time around is more complex and requires Solomonic wisdom to obviate rendering an opinion that may exacerbate rather than resolve the complex and nuanced situation which both Palestine and Israel find themselves. The Republic of Zambia has been consistent and continues to advocate for relentless efforts aimed at achieving peace in the Middle East based on the principles of the two-state solution, and we shall revert to this issue later. Mr. President, Zambia will rely on the following legal framework in making its arguments. That is to say, number one, the United Nations Charter. Number two, the Statute of the International Court of Justice. Number three, let me just say the Oslo I Accord, instead of regurgitating the full citation. Number four, the Oslo II Accord. And number five, we rely on the advisory opinion which this court rendered with regards to the consequences of the construction of the wall in the occupied Palestinian territory in 2004. Number six, we also rely on the United Nations Security Council resolutions 242 of 1967 and 338 of 1973. Mr. President, we recognize the inalienable right of the Palestinian people to self-determination. We also recognize the legitimate security needs of the Israeli people. Both Israel and Palestine have a duty to respect international human rights law and international humanitarian law. Therefore, any recourse to the conflict should not be one that puts the blame squarely on one party, but rather one that advances a negotiated solution that culminates in a two-state solution. May it be on record, my Lord, that our support for the Palestinian people's right to self-determination remains steadfast, echoing our consistent position within the United Nations. However, it is imperative to approach this issue with a comprehensive and balanced perspective. Zambia believes that any declaration addressing the Israeli-Palestinian conflict must acknowledge the complexities and nuances inherent in the circumstances and the need to take serious consideration of the difficult situation that both parties find themselves as they strive to defend the respective rights of their people. Mr. President, sir, the Republic of Zambia is cognizant of the fact that at the center of the conflict is the territorial dispute and rejection of the partition plan since the creation of the State of Israel in 1948. The United Nations has historically attempted to resolve this conflict through political processes, which culminated in various peace treaties and Security Council resolutions, such as the Oslo Accords and the Security Council resolutions 242 of 1967 and 338 of 1973. There is also the historic exchange of letters between the late former Prime Minister of Israel, may so rest in peace, Isaac Rabin, and the late former Palestinian Liberation Organization chairman, may so rest in peace, the late Yasser Arafat, dated 9 September 1993. This exchange, Your Lordship, and members of the court, which carries no time limit on its validity, contains mutual declarations of recognition, reciprocal commitments to negotiate peace. To this end, the parties, and I mean both Israel and Palestine, are expected to refrain from undermining or prejudicing the accords through unilateral or third-party initiatives or actions, and from any other initiatives and attempts to impose a solution that seeks to circumvent the agreed-upon negotiations. Mr. President, members of the court, there is an argument that negotiations have proved to be ineffective in the past, and therefore the resort to advisory opinions. The Republic of Zambia respectfully submits that the Israelis, the Palestinians, regional states, and the broader international community, and indeed the United Nations Security Council, should consider the reasons why the negotiations failed in the first place and address that issue before resorting to a solution that seeks to bypass the agreed-upon negotiations. In the case of the Israeli-Palestinian conflict, if it is established that negotiations have been ineffective, it may call then for an addendum to the Oslo I Accord to amend Article 15, which provides for negotiations, and replace that clause with another mode of dispute settlement. Mr. President, in any event, one may also argue that the advisory opinion by this court on the legal consequences of the construction of the wall in the occupied Palestinian territory in 2004 was also ineffective. Should it then be argued also that the international community must abandon advisory opinions of this court? We submit that postmortems are important in evaluating the challenges and limitations of the dispute settlement mechanisms that are applied to resolve the problem before resorting to another mode. Mr. President and members of the court, it is our firm submission that the Oslo Accords remain the only valid, agreed legal source of authority for the division of control, powers, and responsibilities between Palestine and Israel over the various parts of the territories. Article 15 of the Oslo I Accord prescribes negotiations as the mode of resolving disputes. No other legal or normative framework, whether through international conventions, declarations, or UN resolutions, has substituted the agreed-upon, still valid legal framework of the Oslo Accords, unless and until the same are amended. Zambia proposes that the final determination of this matter would be for the parties to resolve their dispute through a settlement means of their choice, which is negotiations. The just and sustainable two-state solution cannot be imposed from the outside through an advisory opinion. The Republic of Zambia fully supports this recognized and established framework for the resolution of the Israeli-Palestinian conflict. The court needs to safeguard the established legal framework as endorsed by the parties' bilateral agreements and reflected in repeated United Nations resolutions, both with respect to the administration of the territory pending a negotiated outcome and with respect to reaching a permanent status solution or resolution that addresses legitimate needs and aspirations of both sides. The parties have an obligation under Article 31, Clause 7 of the 1995 Palestinian Interim Agreement on the West Bank and the Gaza Strip, which is Oslo II Accord, not to initiate or take any step that would change the status of the West Bank and the Gaza Strip pending the outcome of the permanent status negotiations. Mr. President, members of the court, this court did announce or pronounce itself on the importance of continued negotiations in its advisory opinion of 2004 on the legal consequences of the construction of the wall in the occupied Palestinian territory. The court encouraged efforts to achieve a negotiated solution to the conflict and the establishment of a Palestinian state existing side by side with Israel for peace and security for all in the region. This court, while noting that illegal actions and unilateral decisions were taken on both sides, confirmed the continued validity of the legal framework by stipulating that this situation can be ended only through implementation of the agreements in good faith. Mr. President, members of the court, as we conclude, we wish to submit that the court is neither the only dispute resolution mechanism available, nor is it the best in all circumstances. Let me repeat that one. As we conclude, we wish to submit that the court is neither the only dispute resolution mechanism available, nor is it the best in all circumstances. The best dispute resolution mechanism is one that delivers optimal and sustainable solutions depending on the peculiar circumstances of each case. And there is certainly no one-size-fits-all. Where, for instance, the objective of the dispute resolution mechanism is to blame one party or the other, or to solely determine a winner or a loser, then we have no doubt that the court is the best forum. Mr. President, those of us that have practiced law for many years know how in determining a winner and a loser, the court decisions have, in almost all cases, left permanently ruined relationships between neighbors on a difference which could have been resolved in a better way by adopting alternative dispute mechanisms such as a negotiated settlement conciliation, or mediation. In conclusion, therefore, the Republic of Zambia reiterates the call for relentless efforts aimed at achieving peace in the Middle East based on the principles of a two-state solution. Both Israel and Palestine have a duty to respect international human rights law and international humanitarian law. Therefore, any recourse to the conflict should not be one that puts the blame squarely on one party, but rather one that advances a negotiated solution, which culminates in a two-state solution. The Republic of Zambia surmises that the court should not exercise its jurisdiction under Article 65 of the statute, but rather give deference and sanctity to the bilateral agreements existing between the two states, and indeed give deference to the doctrine of party autonomy and pacta sunt servanda. We argue in the alternative, we conclude in the alternative that should the court decide to exercise its jurisdiction to render the sought advisory opinion, which, as we said, it has the jurisdiction, then the opinion should encourage and assist the parties to respect the legal commitments, including conducting credible negotiations, and not make it more difficult for them to do so. This is also anchored on the fundamental international legal principle of pacta sunt servanda. In this way, Your Lordship, the court would essentially be upholding the sovereign rights of the two parties. Mr. President, I thank you for your attention.
I thank the delegation of Zambia for its presentation. I invite the next participating delegation, the League of Arab States, to address the court, and I call Mr. Abdul Hakim Al-Rifai to the podium.
Thank you, Mr. President, honorable members of the court. It's a great honor and privilege to appear before you today on behalf of the League of Arab States. I would like to read a statement by His Excellency, Mr. Ahmed Abul Ghait, Secretary General of the League of Arab States. The League of Arab States attaches high importance to the present proceedings, hoping that they contribute to safeguarding the principles of international law, to uphold the inalienable rights of the Palestinian people to self-determination, and end the last oppressive, expansionist, apartheid, settler, colonial occupation still standing in the 21st century. The persistence of this occupation, acts of genocide, ethnic cleansing, war crimes, crimes against humanity, displacement of populations, imprisonment of Palestinians behind illegal segregation walls, expansion of illegal settlements, creating new political realities on the ground, aiming at complicating the dismantling of the occupation. All will never discourage Palestinians from claiming their legitimate, inalienable rights. The insistence on placing Israel above the law through the politicization of accountability and adopting double standards in the application of justice is a direct threat to international peace and stability. Ending Israel's total impunity and subjecting it, like any other state, to the universal rules of international law will help annul its pretexts to systematically reject peace initiatives, the most serious of which is the Arab Peace Initiative of 2002, which offered full normalization of relations with all Arab states in exchange of Israel only respecting its already established obligations under the bodies of international law, human rights laws, and the United Nations Security Council and General Assembly resolutions. This prolonged occupation is an affront to international justice. The failure to bring it to an end has led to the current horrors perpetrated against the Palestinian people, amounting to genocide. There can be no moral or juridical justification for occupying lands, killing, terrorizing, and displacing their populations. The League of Arab States trusts the esteemed court will confirm the illegality of this occupation and unambiguously rule on the legal consequences for all parties, especially those who turn a blind eye, facilitate, assist, or participate in any way in perpetuating this illegal situation. Only the rule of law, not the prevailing law of the jungle, will pave the way to peace in the whole region. Ending the occupation is the gateway to peaceful coexistence. Thank you very much for your kind attention. I now respectfully request, Mr. President, that you call on Dr. Ralph Wild, Senior Counsel and Advocate, to address the legal questions before the Court. Thank you.
I thank Mr. Al-Rifai. I now give the floor to Mr. Ralph Wild. You have the floor, sir.
Mr. President, distinguished members of the Court, it's a great honour and privilege to appear before you and to represent the League of Arab States. The Palestinian people have been denied the exercise of their legal right to self-determination through the more than century-long violent, colonial, racist effort to establish a nation-state exclusively for the Jewish people in the land of mandatory Palestine. When this began after the First World War, the Jewish population of that land was 11%. Forcibly implementing Zionism in this demographic context has necessarily involved the extermination or forced displacement of some of the non-Jewish Palestinian population, the exercise of domination over and subjugation, dispossession and immiseration of remaining non-Jewish Palestinians, the emigration to that land of Jewish people, regardless of any direct personal link, and the denial of Palestinian refugees the right to return, all operating through a racist distinction privileging Jewish people over non-Jewish Palestinian people. This has necessitated serious violations of all the fundamental Jus Cogens and erga omnes norms of international law. The right of self-determination, the prohibitions on aggression, genocide, crimes against humanity, racial discrimination, apartheid and torture, and the core protections of IHL. Today, I will address, first, violations of international law arising out of the regime of racial domination, apartheid, perpetrated against the Palestinian people across the entire land of historic Palestine. And then, second, the existential illegality of Israel's occupation of the Palestinian Gaza Strip and West Bank, including East Jerusalem, since 1967. As a necessary prerequisite, I must begin with this special right granted to the Palestinian people in the League Covenant. The legal right of self-determination of the Palestinian people originates in the sacred trust obligations of Article 22 of the League Covenant, part of the Versailles Treaty. Palestine, an A-class mandate under British colonial rule, was, after the First World War, supposed to have its existence as an independent state provisionally recognized, a sui generis right of self-determination. The UK and other members of the League Council attempted to bypass this, incorporating the 1917 Balfour Declaration commitment to establishing a national home for the Jewish people in Palestine into the instrument stipulating how the mandate would operate. However, the Council had no legal power to bypass the covenant in this way. It acted ultra vires, and the relevant provisions were legally void. There was and is no legal basis in that mandate instrument for either a specifically Jewish state in Palestine or the UK's failure to discharge the sacred trust obligation to implement Palestinian self-determination. After the Second World War, a self-determination right applicable to colonial peoples generally crystallized in international law. For the Palestinian people, this essentially corresponded to and supplemented the pre-existing covenant right regarding the same single territory. The 1947 proposal to partition Palestine was contrary to this, the Arab rejection and affirmation of the legal status quo. In 1948, then, Palestine was, legally, a single territory with a single population enjoying a right of self-determination on a unitary basis. Despite this, a state of Israel specifically for Jewish people was proclaimed in 1948 by those controlling 78%, more than 3/4 of Palestine, accompanied by the forced displacement of a significant number of the non-Jewish Palestinian population, the Nakba catastrophe. This illegal secession was an egregious violation of Palestinian self-determination. Israel's statehood was recognized, and Israel admitted as a UN member despite this illegality. Israel is not the legal continuation or successor of the mandate. This violation of Palestinian self-determination is ongoing and unresolved. Two key elements are, first, Palestinian people not displaced from the land proclaimed to be of Israel in 1948 and their descendants have been forced to live as citizens, presently they constitute 17.2%, of a state conceived to be of and for another racial group, under the domination of that group, necessarily treated as second class because of their race. Second, Palestinian people displaced from that land and their descendants cannot return. These are serious breaches of the right of self-determination, the prohibitions of racial discrimination and apartheid, and the right of return. They must end immediately. As if this ongoing Nakba was not catastrophic enough, in 1967, Israel captured the remaining 22% of historic Palestine, the Gaza Strip and West Bank, including East Jerusalem, the Nakba. It's maintained that use of force to remain in control for the 57-year period since. For more than half a century then, a state defined to be of and for Jewish people exclusively has governed the entire land of historic Palestine and the Palestinian people there. And the regime of racial domination, apartheid, and denying return has been extended throughout. In the case of Palestinians living in the occupied territory, this has involved the same serious violations of international law, supplemented by serious violations of norms applicable in occupied territory. Indeed, these people are subject to an even more extreme form of racist domination, as they aren't even citizens of the state exercising authority over them. Even in East Jerusalem, which Israel has purported to annex, the majority non-Jewish Palestinian residents don't have citizenship, whereas Jewish residents, including illegal settlers, are citizens. Just as in territorial Israel, in occupied territory, these serious violations concerning how Israel exercises authority over the Palestinian people must end immediately. However, here, a more fundamental matter must also be addressed: the illegality of the exercise of authority itself. The enduring Palestinian right of self-determination means that the Palestinian people and the state of Palestine, not Israel, are sovereign over the territory Israel captured in '67. For Israel, the land is extraterritorial and, given what I said about the mandate, territory over which it has no legal sovereign entitlement. Despite this, Israel has purported to annex East Jerusalem and taken various actions there and in the rest of the West Bank, constituting de jure and de facto purported annexation, including implanting settlements. It is Israeli policy that Israel should be not only the exclusive authority over the entire land between the river and the sea, but also the exclusive sovereign authority there. This constitutes a complete repudiation of Palestinian self-determination as a legal right, since it empties the right entirely of any territorial content. Actualizing this through de facto and de jure purported annexation is, first, a serious violation of Palestinian self-determination, and second, because it's enabled through the use of force, a violation of the prohibition on the purported acquisition of territory through the use of force in the law on the use of force, and so an aggression. Serious violations of further areas of law regulating the conduct of the occupation are also being perpetrated, notably the prohibitions on implanting settlements and altering, unless absolutely prevented, the legal, political, social and religious status quo. The occupation is therefore existentially illegal because of its use to actualize purported annexation. To end this serious illegality, it must be terminated. Israel must renounce all sovereignty claims and all settlements must be removed immediately. However, this is not the only basis on which the occupation's existential legality must be addressed. We need to delve deeper into both the law of self-determination and the law on the use of force. Beginning with self-determination, this right, when applied to the Palestinian people in the territory Israel captured in '67, is a right to be entirely self-governing, free from Israeli domination. Consequently, the Palestinian people have a legal right to the immediate end of the occupation, and Israel has a correlative legal duty to immediately terminate the occupation. This right exists and operates simply and exclusively because the Palestinian people are entitled to it. It does not depend on others agreeing to its realization. It is a right. It's a repudiation of trusteeship, whereby colonial peoples were ostensibly to be granted freedom only if and when they were deemed ready because of their stage of development, determined by the racist standard of civilization. The anti-colonial self-determination rule replaced this with a right based on the automatic, immediate entitlement of all people to freedom, without preconditions. In the words of General Assembly 1514, inadequacy of preparedness should never serve as a pretext for delaying independence. Some suggest that the Palestinian people were offered and rejected deals that could have ended the occupation, and therefore Israel can maintain it pending a settlement. Even assuming arguendo the veracity of this account, the deals involved a further loss of the sovereign territory of the Palestinian people. Israel cannot lawfully demand concessions on Palestinian rights as the price for ending its impediment to Palestinian freedom. This would mean Israel using force to coerce the Palestinian people to give up some of their peremptory legal rights, illegal in the law on the use of force, and necessarily voiding the relevant terms of any agreement reached. The Palestinian people are legally entitled to reject a further loss of land over which they have an exclusive legal peremptory right. Any such rejection makes no difference to Israel's immediate legal obligation to end the occupation. Turning to the law on the use of force, Israel's control over the Palestinian territory since '67 as a military occupation is an ongoing use of force. As such, its existential legality is determined by the law on the use of force as a general matter beyond the specific issue of annexation. Israel captured the Gaza Strip and West Bank from Egypt and Jordan in the war it launched against them and Syria. It claimed to be acting in self-defense, anticipating a non-immediately imminent attack. The war was over after 6 days. Peace treaties between Israel and Egypt and Jordan were subsequently adopted. Despite this, Israel maintained control of the territory, continuing the use of force enabling its capture. Israel's '67 war was illegal in the Jus ad Bellum, even assuming, arguendo, its claim of a feared attack. States can't lawfully use force in non-immediately imminent anticipatory self-defense. Alternatively, assuming, again arguendo, that the war was lawful, the justification ended after 6 days. However, the Jus ad Bellum requirements continued to apply to the occupation as itself a continuing use of force. In 1967, with self-determination well established in international law, states could not lawfully use force to retain control over a self-determination unit captured in war unless the legal test justifying the initial use of force also justified, on the same basis, the use of force in retaining control. Moreover, this justification would need to continue not only in the immediate aftermath, but for more than half a century. Manifestly, this legal test has not been met. Israel's exercise of control over the Gaza Strip and West Bank through the use of force has been illegal in the Jus ad Bellum since the capture of the territory, or at least very soon afterwards. The occupation is therefore, again, existentially illegal in the law on the use of force and aggression, this time as a general matter, beyond illegality specific to annexation. To terminate this serious violation, the occupation must likewise end immediately. What of Israel's current military action in Gaza? This is not a war that began in October 2023. It's a drastic scaling up of the force exercised there and in the West Bank on a continual basis since '67. A justification for a new phase in an ongoing illegal use of force cannot be constructed solely out of the consequences of violent resistance to that illegal use of force. Otherwise, an illegal use of force would be rendered lawful because those subject to it violently resisted. Circular logic with a perverse outcome. More generally, Israel cannot lawfully use force to control the Palestinian territory for security purposes pending an agreement providing security guarantees. States can only lawfully use force outside their borders in extremely narrow circumstances. Beyond that, they must address security concerns non-forcibly. The USA, UK and Zambia suggested here that there is a sui generis applicable legal framework, an Israeli-Palestinian lex specialis. This somehow supersedes the rules of international law determining whether the occupation is existentially lawful. Instead, we have a new rule justifying the occupation until there is a peace agreement meeting Israeli security needs. This is the law as these states would like it to be, not the law as it is. It has no basis in Resolution 242, Oslo, or any other resolutions or agreements. Actually, you are being invited to do away with the very operation of some of the fundamental peremptory rules of international law itself. As a result, the matters these rules conceive as rights vested in the Palestinian people would be realized only if agreement is reached and only on the basis of such agreement. At best, if there is an agreement, this means one that need not be compatible with Palestinian peremptory legal rights, determined only by the acute power imbalance in Israel's favor. At worst, if there is no agreement, this means that the indefinite continuation of Israeli rule over the Palestinian people in the OPT on the basis of racist supremacy and a claim to sovereignty would be lawful. This is an affront to the international rule of law, to the UN Charter imperative to settle disputes in conformity with international law, and to your judicial function as guardians of the international legal system. A final potential basis sometimes invoked to justify continuing the occupation should be addressed. Occupation and human rights law, applicable to illegal and lawful occupations alike, oblige Israel to address security threats in occupied territory. However, they only regulate the conduct of an occupation when it exists. They don't also provide a legal basis for that existence itself. Existential legality is determined by the law of self-determination and the jus ad bellum only. There is no backdoor legal basis for Israel to maintain the occupation through the imperatives of occupation and human rights law. In sum, the occupation of the Palestinian Gaza Strip and West Bank, including East Jerusalem, is existentially illegal on two mutually reinforcing bases. First, the law on the use of force. Here the occupation is illegal both as a use of force without valid justification and because it's enabling an illegal purported annexation. As such, it is an aggression. Second, the law of self-determination. Here, it's illegal again because of the association with illegal purported annexation, and also, more generally, because it is quite simply an exercise of authority over the Palestinian people that by its very nature violates their right to freedom. This multifaceted existential illegality involving serious violations of peremptory norms has two key consequences. First, the occupation must end. Israel must renounce its claim to sovereignty over the Palestinian territory. All settlers must be removed immediately. This is required to end the illegality, to discharge the positive obligation to enable immediate Palestinian self-administration, and because Israel lacks any legal entitlement to exercise authority. Second, in the absence of the occupation ending, necessarily everything Israel does in the Palestinian territory lacks a valid international legal basis and is, therefore, subject to the Namibia exception, invalid. Not only those things violating the law regulating the conduct of the occupation. Those norms entitle and require Israel to do certain things, but this doesn't alter the more fundamental position from the law on the use of force and self-determination that Israel lacks any valid authority to do anything, and whatever it does is illegal, even if compliant with or pursuant to the conduct regulatory rules. I will close by quoting Palestinian academic and poet Rifat Al-Ariyeh from his final poem posted 36 days before he was killed by Israel in Gaza on the 6th of December 2023. If I must die, you must live to tell my story. If I must die, let it bring hope. Let it be a story. Thank you for your attention.
I thank the delegation of the Arab League for its presentation. And before I invite the next delegation to make its oral statement, the court will observe a break for 10 minutes. The sitting is suspended. Please be seated. The sitting is resumed. J'invite maintenant la délégation participante suivante, celle de l'Organisation de la coopération islamique, à prendre la parole devant la Cour et appelle son Excellence M. Brahim Hussein Taha Alabar. Vous avez la parole, monsieur.
Monsieur le Président, Mesdames et Messieurs les membres de la Cour, j'ai l'honneur de me présenter devant vous au nom de l'Organisation de la coopération islamique pour vous exprimer la confiance que nous plaçons en notre haute juridiction afin que, par l'avis consultatif demandé, vous éclairerez davantage l'Assemblée générale des Nations unies dans sa tâche. L'Organisation de la coopération islamique recouvre 57 États membres. Elle est la voix collective du monde islamique. Cette organisation intergouvernementale a été créée suite à l'incendie criminel en 1969 de la mosquée d'Al-Aqsa de Jérusalem. C'est ainsi que la charte de notre organisation mentionne parmi ses objectifs notre soutien aux droits du peuple palestinien à créer son État souverain avec pour capitale Al-Quds al-Sharif. C'est dire que notre organisation est particulièrement attentive au juste combat de ce peuple et se trouve profondément préoccupée par l'agression en cours qu'Israël, la puissance occupante, mène contre le peuple palestinien à Gaza et le risque vital que les opérations d'Israël lui font courir aussi ainsi qu'à notre organisation a-t-elle tenu un sommet extraordinaire à Riyad le 11 novembre dernier consacré à cette question. Je voudrais vous informer ici des positions prises à cette occasion par l'organisation que je représente. Devant la gravité de la situation, nous avons mis en garde contre les conséquences de la guerre menée par l'occupant israélien dans la bande de Gaza. Nous condamnons cette agression qui dure depuis bientôt 5 mois, faisant des milliers de victimes et qui a occasionné des crimes de guerre massifs et d'un risque de génocide, comme vous l'avez reconnu dans votre ordonnance du 26 janvier dernier. Nous condamnons avec la même force les crimes commis par Israël, la puissance occupante et les colons en Cisjordanie et dans la ville d'Al-Quds al-Sharif. Nous dénonçons le refus par Israël, la puissance occupante, de mettre fin à son occupation illégale et du territoire palestinien aux violations multiples et des normes de droit international que la poursuite de cette occupation entraîne. Et nous déplorons l'incapacité du Conseil de sécurité à mettre en œuvre le droit international pour enrayer cette spirale de violence et rendre justice au peuple palestinien. Monsieur le Président, Mesdames et Messieurs membres de la Cour, c'est dans ce contexte que nous avons rappelé qu'une paix juste, durable et globale sur la base de la solution des 2 États est le seul moyen d'assurer la sécurité et la stabilité de tous les peuples de la région et de protéger des cycles de violence et de guerre. Dans le même esprit, nous avons demandé que tous les pays cessent d'exporter des armes et des munitions aux autorités d'occupation, sachant que l'armée et les colons les utilisent contre le peuple palestinien. À cette occasion, nous avons pris soin de dénoncer toutes les formes de haine et de discrimination et toutes les thèses qui consacrent la culture de la haine et de l'extrémisme. Et nous avons proclamé l'impératif pour la communauté internationale de prendre des mesures immédiates et rapides pour mettre fin aux massacres
et à la prise pour cible des civils palestiniens de façon à confirmer qu'il n'y a aucune différence entre une vie et une autre, ni de discrimination sur la base de la nationalité, de la race ou de la religion. Telles sont les conditions sans lesquelles aucune paix durable n'est possible. Nous attendons aussi de votre Cour que soit condamnée la colonisation accélérée de Jérusalem et ainsi que les attaques israéliennes menées contre les lieux saints islamiques et chrétiens d'Al-Quds. Aussi, espérons-nous que l'avis consultatif que vous allez prendre soit à l'occasion de rappeler sous votre autorité le devoir impératif qui incombe à Israël, la puissance occupante, de mettre fin à son occupation. Le territoire palestinien est prolongé depuis trop longtemps et d'en réparer toutes les conséquences. Maintenant, notre Conseil, Madame Chemilier-Gendreau, à qui je vous prie, Monsieur le Président, de bien vouloir lui donner la parole, vous exposera les aspects juridiques sur lesquels l'Organisation de la coopération islamique pense pouvoir apporter encore quelques éclaircissements. Je vous remercie.
Je remercie Son Excellence Monsieur Taha. Je donne à présent la parole à Madame Monique Chemilier-Gendreau. Madame, vous avez la parole.
Merci, Monsieur le Président. C'est au nom de l'Organisation de la coopération islamique que j'ai l'honneur de me présenter devant vous ce matin. Et je reviendrai ici sur 3 éléments de la situation sur laquelle vous aurez à rendre votre avis. Quelques-uns des États participant à la présente procédure ont demandé à votre juridiction de décliner sa compétence. Ils estiment que l'avis demandé perturberait des négociations prétendument en cours entre les protagonistes, alors que ces négociations seraient le seul chemin vers la paix. Mais il faut préalablement établir les faits. Les établir dans toute leur vérité est une condition indispensable à l'établissement de la justice. Y a-t-il des négociations en cours entre Israël et la Palestine? La vérité sur cette question, c'est qu'il n'y en a plus. Il s'agit d'un mythe qui a été entretenu artificiellement longtemps, mais qui, à la lumière des événements, s'est effondré de l'aveu même des intéressés. La Cour est-elle en mesure d'établir la vérité sur ce point? Certains participants à cette procédure ont soutenu que vous devriez décliner votre compétence en raison d'une supposée difficulté à accéder aux faits. Mais le dossier qui vous a été fourni par les services des Nations Unies eux-mêmes comporte tous les éléments sur lesquels vous pouvez fonder l'avis qui vous est demandé. Il est ainsi avéré que les accords d'Oslo remontent à 1993 et 1995, que leurs objectifs devaient être atteints au plus tard en 1999, que cette échéance n'a pas été tenue, que par la suite des réunions ont eu lieu à Sharm el-Sheikh en 1999, à Camp David en 2000, et sont restées infructueuses. À partir de là, ni le redéploiement d'Israël, ni le renforcement de l'autonomie de l'autorité palestinienne ne se sont concrétisés. L'horizon des accords d'Oslo était lié au respect des résolutions 242 et 338 du Conseil de sécurité qui y sont explicitement mentionnées. Ce respect impliquait le retrait par Israël du territoire palestinien occupé en 1967. L'article 18 de la Convention de Vienne sur le droit des traités dispose que les États parties à un accord doivent s'abstenir d'actes qui priveraient ce traité de son objet et de son but. Or, Israël, en implantant à marche forcée des colonies juives sur le territoire palestinien, a privé les accords d'Oslo de leur objet et de leur but. Et les responsables politiques d'Israël ont confirmé la mort des négociations en dénonçant les accords d'Oslo dès les années 2000, c'est-à-dire il y a plus de 20 ans. Ariel Sharon avait alors déclaré au journal Haaretz, je le cite, « On ne continue pas Oslo, il n'y aura plus d'Oslo, Oslo c'est fini ». Fin de citation. Plus récemment, le 12 décembre 2023, le Premier ministre Benjamin Netanyahou affirmait, je le cite, « Je ne permettrai pas à Israël de répéter l'erreur des accords d'Oslo ». Fin de citation. Votre Cour reconnaîtra que nous sommes ici devant un cas particulièrement remarquable de manquement à la bonne foi. Israël, membre des Nations Unies, est lié par les résolutions de cette organisation ainsi que par les engagements particuliers qu'il a pris. Au mépris de tout ce corpus, cet État s'approprie le territoire de la Palestine, expulse son peuple et lui refuse par tous les moyens le droit à l'autodétermination. Vous avez eu l'occasion de rappeler dans votre arrêt de 2018 que dès lors que des États s'engagent dans une négociation, je vous cite, « ils sont alors tenus de les mener de bonne foi ». Fin de citation. Or, il apparaît que dès son engagement dans les négociations d'Oslo, Israël a manqué à la bonne foi. Aussi n'y a-t-il aucun horizon de négociation qu'il faudrait protéger, mais seulement une guerre en cours et le refus des autorités israéliennes d'ouvrir toute perspective politique fondée sur le droit international. Voilà pourquoi l'argument selon lequel votre compétence pour rendre l'avis demandé ferait obstacle à une paix négociée est un argument sans fondement. Je voudrais maintenant, et ce sera mon second point, rester encore un moment sur la question des négociations pour faire à ce propos une remarque de fond. Les Palestiniens ne recouvreront pas leurs droits légitimes à travers une négociation bilatérale directe avec Israël. Il y a à cela deux écueils. Le premier tient à l'inégalité écrasante entre les deux parties. La Palestine est sous la domination militaire d'Israël et ses représentants sont dans une position de faiblesse structurelle. Dès lors, toute négociation est biaisée et le traité qui en résultera sera nécessairement un traité inégal. Le second écueil tient au fait que dans les négociations qui ont eu lieu jusqu'ici, Israël a tenté de faire admettre par les Palestiniens des entailles aux droits fondamentaux qu'ils détiennent du droit international. La violation principale, source elle-même des autres violations, consiste dans le refus persistant qu'oppose Israël au droit du peuple palestinien à disposer de lui-même. À aucun moment, depuis la fin du mandat britannique en 1947, les dirigeants d'Israël n'ont sincèrement admis qu'un État palestinien pouvait coexister auprès d'eux sur la terre de Palestine. Le Premier ministre d'Israël a confirmé le 20 janvier dernier son opposition à une souveraineté palestinienne. Lorsqu'Israël a feint de négocier le droit des Palestiniens à devenir un État, c'était pour n'en concéder qu'une caricature. Un pouvoir démilitarisé, enclavé, éclaté sur un territoire morcelé, avec un accès réduit à ses ressources naturelles. Et pourtant, le droit des peuples à disposer d'eux-mêmes a la valeur d'une norme de jus cogens. Il n'est pas un droit constitutif qui ne pourrait naître que de sa reconnaissance par Israël. Il est un droit déclaratif, inhérent à la situation de peuple colonisé des Palestiniens. Il existe dès le moment où ce peuple a décidé de le revendiquer. De ce fait, et dans toute sa plénitude, ce n'est pas un droit négociable. Israël a occupé à partir de 1967 le territoire palestinien suite à une action militaire qui a été menée en violation de la règle centrale d'interdiction du recours à la force. Il occupe donc un territoire sur lequel il n'a aucun droit. Il doit s'en retirer. Cela non plus n'est pas négociable. En colonisant ce territoire, Israël viole l'interdiction du transfert de la population de la puissance occupante dans le territoire occupé. Et le projet israélien est officiellement de persister dans cette illégalité. De 700 000 qu'ils sont actuellement en Cisjordanie et à Jérusalem, les colons doivent dépasser le million aussi rapidement que possible, annonçait le ministre Smotrich le 12 juillet 2023. Israël a officialisé cette violation en inscrivant dans sa loi fondamentale de 2018 le développement des colonies juives comme une valeur de base de la société israélienne. Pourtant, le droit international exige le démantèlement de toutes ces colonies. Nous sommes, là encore, devant une obligation qui n'est pas négociable. La sécurité des Palestiniens est gravement menacée. C'est par milliers qu'ils meurent sous les bombes israéliennes à Gaza depuis le 7 octobre. Et en Cisjordanie, selon les sources israéliennes, 367 Palestiniens ont été tués depuis le 7 octobre, dont 94 enfants, et 2960 Palestiniens ont été arrêtés. Les sources palestiniennes estiment que ces chiffres sont fortement sous-évalués. Les colons implantés en Cisjordanie et à Jérusalem-Est exercent librement leur violence contre les Palestiniens. Ils y sont encouragés et des armes leur sont distribuées par l'État d'Israël lui-même. La dépossession de leurs terres et la répression dont sont l'objet les Palestiniens se sont ainsi intensifiées depuis quelques mois. Et se développe une politique de discrimination constitutive d'apartheid. Toutes ces violations de droits fondamentaux doivent cesser. Une fois de plus, cela n'est pas négociable. Pour rendre la vie attendue, votre Cour aura à se pencher sur la question de Jérusalem. Cette ville n'a pas été incluse dans le territoire destiné à Israël par la résolution 181 de l'Assemblée générale des Nations unies proposant un plan de partage de la Palestine. Lors de son admission aux Nations unies en 1949, Israël a solennellement accepté les principes de la Charte des Nations unies et des résolutions votées par ses organes. Il y avait donc la reconnaissance du fait que Jérusalem ne lui était pas attribuée. Cependant, s'emparant de la ville par la force en 1948 pour la partie ouest et en 1967 pour la partie est, Israël en a fait sa capitale réunifiée en 1980. Depuis, Jérusalem-Est est soumise à une israélisation forcée par une intense colonisation. Celle-ci est considérée comme irréversible par les responsables israéliens. Toutefois, Jérusalem-Est n'a pas d'autre statut que celui d'être un territoire occupé militairement par une puissance étrangère, comme l'ensemble du territoire palestinien occupé depuis 1967. Israël doit s'en retirer au profit du peuple palestinien, comme l'ont exigé constamment les résolutions pertinentes du Conseil de sécurité et de l'Assemblée générale. Et les lieux saints doivent être préservés et ouverts à la liberté de tous ceux qui souhaitent s'y rendre. Cela non plus n'est pas négociable. Ignorant ces impératifs du droit commun, Israël voudrait légaliser les actions illicites que je viens de mentionner en les inscrivant dans un accord. Or, ce qui apparaît de l'analyse juridique de la situation, c'est que sur la Palestine, Israël n'a aucun droit, il n'a que des devoirs. Et de leur respect dépend la préservation de l'ordre public international fondé sur des normes communes et non dérogeables. la responsabilité de leur respect incombe aux Nations unies en charge du maintien de la paix. Elles ont été investies du dossier de la décolonisation de la Palestine par l'échec du mandat confié au Royaume-Uni. Elles sont la seule autorité à même de résoudre, sur des bases conformes au droit, la situation créée par cet échec depuis des décennies. Et s'il faudra bien que la paix découle d'un accord entre les parties, celui-ci devra être conclu sous les auspices des Nations unies, garante du respect du droit, et non sous le parrainage arbitraire d'États tiers manquant d'objectivité. Ainsi, la manière dont les choses seront menées, à partir des conclusions de votre avis, devra permettre que l'accord par lequel les Palestiniens seront rétablis dans l'intégralité de leurs droits respecte les normes fondamentales jusqu'ici objet de tentatives de contournement. Et si ce n'était pas le cas, le futur traité de paix tomberait sous le coup de la Convention de Vienne sur le droit des traités qui dispose, je la cite, « est nul tout traité qui, au moment de sa conclusion, est en conflit avec une norme impérative du droit international général ». J'en viens maintenant, et c'est mon dernier point, à la seconde question qui est posée à votre cour par l'Assemblée générale des Nations unies. Vous êtes interrogé sur le statut juridique de l'occupation et sur les conséquences juridiques qui en découlent. Vous aurez ainsi à examiner l'occupation par Israël du territoire palestinien à la lumière de tous les champs du droit international. Il s'agit d'abord du jus ad bellum, ce droit qui régit l'usage de la force par les États. Il comporte la norme majeure d'interdiction de recourir à la menace ou à l'emploi de la force contre l'intégrité territoriale ou l'indépendance politique de tout État. Or, c'est bien par l'usage de la force qu'Israël a occupé la Palestine en 1967, comme l'ont rappelé sans relâche le Conseil de sécurité et l'Assemblée générale. Cet emploi de la force est dirigé contre l'intégrité territoriale et l'indépendance politique de la Palestine, aujourd'hui reconnue dans sa qualité d'État par les Nations unies. L'occupation est donc illégale à sa source même. Cette illégalité se manifeste aussi depuis 1967 par la manière dont a été conduite cette occupation. Elle enfreint en effet toutes les conditions posées par le droit de La Haye et de Genève à l'occupation militaire d'un territoire étranger. Ces conditions sont recensées par le manuel du Comité international de la Croix-Rouge. La puissance occupante ne peut pas modifier la structure et les caractéristiques intrinsèques du territoire occupé sur lequel elle n'acquiert aucune souveraineté. Israël n'a cessé de modifier à son profit ces caractéristiques. L'occupation est et doit rester une situation temporaire. Israël occupe la Palestine depuis 66 ans et ses dirigeants affichent ouvertement leur intention de poursuivre indéfiniment cette occupation. Israël doit administrer le territoire dans l'intérêt de la population locale et en tenant compte de ses besoins. Les besoins des Palestiniens sont cruellement méconnus. Israël ne doit pas exercer son autorité pour servir ses propres intérêts et ceux de sa propre population. Toutes les politiques et pratiques d'Israël sont orientées au service des colons israéliens et au mépris des droits et intérêts des Palestiniens. Ainsi, les conditions dans lesquelles Israël a développé l'occupation du territoire palestinien, conditions dont toutes les preuves se trouvent dans les rapports des Nations unies, vous amèneront à conclure que cette occupation, par sa durée et les pratiques déployées par l'occupant, est un prétexte à un projet d'annexion. Celui-ci, officialisé pour ce qui est de Jérusalem, et mise en œuvre de facto pour la Cisjordanie. Quant à Gaza, la guerre totale qui y est menée et les projets annoncés par le gouvernement d'Israël confirment la volonté de cet État de garder la maîtrise de ce territoire. Il résulte de ces constats, comme votre cour ne manquera pas de le confirmer, que l'occupation par Israël du territoire palestinien est frappée d'une triple illégalité. Elle est illégale à sa source, pour être en infraction à l'interdiction de l'emploi de la force. Elle est illégale par les moyens déployés, lesquels sont constitutifs de violations systématiques du droit humanitaire et des droits de l'homme. Elle est illégale enfin par son objectif, celui-ci étant de procéder à l'annexion des territoires palestiniens, privant ainsi le peuple de Palestine de son droit fondamental à disposer de lui-même. Je donnerai quelques réflexions pour finir cette plaidoirie. La violence infondée et impunie qu'Israël exerce sur les Palestiniens entraîne en réponse une autre violence dans un cycle infernal, celui de la vengeance, qui est toujours à l'avantage du plus fort. C'est l'enchaînement meurtrier qui se déroule tragiquement sous nos yeux. Pour le rompre, il faut un tiers impartial, affirmant avec autorité ce que doit être l'application de la norme commune. Il revient à votre cour, à l'occasion de l'avis que vous allez rendre, de ramener l'ensemble de ce conflit sous la lumière du droit. Ce droit permet de dire quelles règles doivent être appliquées à une situation critique, mais aussi quelles mesures peuvent être prises lorsque ces règles sont violées avec persistance. Je rappellerai ici que les conclusions de l'Organisation de la coopération islamique demeurent inchangées par rapport à celles de nos observations écrites, et je me permets d'y renvoyer. Je rappellerai seulement que l'organisation que je représente demande à la Cour d'enjoindre à Israël de cesser toutes les violations qui ont été relevées ici et d'exiger des Nations unies et de leurs États membres qu'ils utilisent toute la gamme des mesures permettant de faire cesser la situation, ce y compris des sanctions contre l'État responsable. Et pour finir, je voudrais, Monsieur le Président, Mesdames et Messieurs les juges, vous citer les propos du contre-amiral israélien Ami Ayalon, qui a dirigé pendant plusieurs années le service du renseignement intérieur israélien. Son chemin personnel l'a amené à s'interroger sur la notion d'ennemi et à mesurer l'impasse où se trouve Israël en ayant choisi la répression violente pour accompagner son refus de la solution politique. Et il conclut une interview donnée il y a quelques semaines à un quotidien français en disant, je le cite, « La communauté internationale devrait jouer un rôle bénéfique. Nous avons besoin que quelqu'un de l'extérieur nous éclaire sur nos erreurs. » Fin de citation. Sauver les Israéliens contre eux-mêmes, voilà à quoi la communauté internationale contribuera à travers l'avis consultatif que vous allez rendre. Je vous remercie de votre attention.
Je remercie la délégation de l'Organisation de la coopération islamique pour son exposé. J'invite la prochaine délégation participante, l'Union africaine, à prendre la parole devant la Cour et appelle Madame la professeure Hajer Geldish à la barre. Vous avez la parole, Madame.
Monsieur le Président, distingués membres de la Cour, c'est un honneur pour moi de représenter l'Union africaine, une organisation comptant 55 États membres. En ce dernier jour de plaidoirie, dans le cadre de la présente procédure consultative, il importe de rappeler le contexte historique et les circonstances tragiques qui ont poussé l'Assemblée générale des Nations unies a demandé, une fois de plus, et regrettablement pour la communauté internationale, un avis consultatif à la Cour sur la situation des territoires palestiniens occupés. L'histoire de la Palestine est une histoire de dépossession, de déplacement, de déshumanisation. C'est l'histoire d'une injustice. C'est la tragédie d'un peuple qui, depuis plus de 7 décennies, est systématiquement soumis et opprimé par le projet colonial israélien, dont l'objectif est d'établir un contrôle complet et exclusif sur l'ensemble du sol de la Palestine, de refuser au peuple palestinien son droit inaliénable de l'autodétermination et de le priver de son droit à vivre librement sur sa terre natale. L'agression israélienne en cours contre Gaza témoigne de cette tragédie. Une population de plus de 2 millions de civils innocents et sans défense est victime d'une campagne de mort et de destruction aveugle, conséquence de la punition collective exercée par la puissance occupante depuis des décennies. C'est pourquoi, lors de la conférence des chefs d'État et de gouvernement des États membres de l'Union africaine, qui était tenue les 17 et 18 février 2024, les chefs d'État et de gouvernement des États membres de l'Union africaine ont exprimé, je cite, leur indignation totale face à la catastrophe humanitaire provoquée par les forces israéliennes dans la bande de Gaza et leur soutien total au peuple palestinien dans la lutte légitime qu'il mène contre l'occupation israélienne. Les chefs d'État et de gouvernement des États membres de l'Union africaine ont aussi dénoncé, je cite, les mesures de punition collective contre les civils, en particulier les tentatives de transfert forcé de la population de Gaza. Par conséquent, l'agression d'Israël contre Gaza n'est rien d'autre qu'une tentative honteuse de créer une nouvelle Nakba, une nouvelle catastrophe destinée à effacer la présence palestinienne en Palestine. En effet, il y a quelques semaines à peine, cette Cour avait reconnu le grave péril auquel est confronté le peuple palestinien à Gaza lorsqu'elle a déterminé que l'Afrique du Sud, un des États membres de l'Union africaine, avait établi la plausibilité de son allégation selon laquelle Israël commettrait un génocide. Rien ne peut justifier les souffrances et les horreurs inexprimables infligées à la population gazaouie. Tel est l'essence de la tragédie palestinienne. Depuis plus d'un siècle, le peuple palestinien endure une succession de Nakba, de la déclaration Balfour aux guerres de 48, de 56, de 67, de 82, en passant par l'établissement et par l'expansion des colonies de peuplement israéliennes et la construction du mur de séparation. À chaque moment de l'histoire, les Palestiniens ont été victimes d'assujettissement, de déplacement, de dépossession. L'escalade de la violence et l'impitoyable machine de guerre dévastent sans cesse la population israélienne. Écoles, lieux de culte, habitations, hôpitaux sont réduits à néant, ne laissant derrière eux que la fumée des bombes qui continuent de pleuvoir sur Gaza. Par miracle, des enfants naissent sous les décombres, mais leur vie reste en sursis étant donné la famine qui les afflige. Des familles endeuillées survivent sans eau, sans nourriture ni électricité, et voient jour après jour leurs espoirs, leurs rêves et leur destin disparaître à jamais sous les ruines. La conscience de l'humanité ne l'oubliera jamais. Monsieur le Président, Mesdames et Messieurs les membres de la Cour, la présente procédure consultative vise à empêcher cette nouvelle injustice résultant non seulement de la force des armes, mais aussi des pratiques israéliennes, comprenant l'annexion de jure et de facto des territoires palestiniens, l'implantation de colonies illégales, la modification du caractère démographique de Jérusalem, ensuite la confiscation et la destruction des biens des Palestiniens, l'expropriation des terres des Palestiniens, la construction de routes, de contournements et l'entretien du mur de séparation. Le fait que ces pratiques israéliennes dans les territoires palestiniens occupés se poursuivent et s'accélèrent est le résultat de l'impunité dont profite Israël et de son mépris du droit des gens et des normes de jus cogens qui sont opposables erga omnes. Ce mépris s'illustre par exemple par la décision d'Israël d'ignorer l'avis consultatif de cette Cour concernant le mur de séparation, ou les innombrables résolutions adoptées par les organes de l'ONU ayant documenté ces violations du droit international. La présente procédure consultative est l'occasion d'enfin tenir Israël responsable de ces actes, mais aussi de mettre fin immédiatement à son impunité et de faire respecter le droit international général, le droit international humanitaire et le droit international des droits humains. Par ailleurs, l'Union africaine participe à cette procédure parce qu'elle se sent investie d'une responsabilité particulière à l'égard du peuple palestinien. Ses États membres ont émergé du fléau colonial, ont mené la lutte contre l'apartheid et la discrimination raciale et ont défendu la cause de l'autodétermination. Notre présence aujourd'hui reflète le sentiment exprimé par les chefs d'État et de gouvernement des États membres de l'Union africaine qui avaient souligné, je cite, « l'importance majeure de la juste cause de la Palestine et la constance de notre position de soutien fondée sur nos valeurs communes contre le colonialisme, l'oppression et l'apartheid, et la solidarité historique de l'Afrique avec le peuple palestinien dans sa quête légitime de liberté et d'un État indépendant. » Monsieur le Président, Mesdames et Messieurs les membres de la Cour, à l'occasion de l'avis consultatif de la Cour sur l'archipel des Chagos, l'Union africaine a été témoin de l'autorité et de l'impact des décisions de la Cour. Cet avis a en effet contribué à quasiment mettre fin à l'une des dernières formes vivantes de colonialisme en Afrique. Comme dans cette affaire, la question devant vous ne porte nullement sur un contentieux opposant deux parties égales, mais une situation asymétrique dans laquelle un peuple opprimé est confronté à une puissance occupante. La Cour saura donc confirmer, de la même manière que dans l'affaire Chagos, le droit du peuple palestinien à l'autodétermination et à la liberté, et à faire en sorte que l'État de Palestine soit en mesure d'exercer sa pleine souveraineté et son indépendance sur ses territoires de Cisjordanie, de Gaza et sur sa capitale, Jérusalem-Est. Avant de demander humblement à la Cour de donner la parole à mon collègue, le professeur Mohamed Hilal, j'aborderai la question de la compétence. Nos observations à cet égard seront brèves. la grande majorité des participants avait dit, d'ailleurs, que la présente procédure, pratiquement, il n'y a rien qui s'oppose à l'exercice par la Cour de sa fonction consultative. C'est une position que l'Union africaine partage pleinement et entièrement. En effet, la Cour a déjà confirmé sa compétence dans le cadre de la demande d'avis consultatif portant sur la même situation factuelle dans l'avis sur le mur, et il n'y a aucune raison de s'écarter de son analyse. De plus, la jurisprudence de la Cour a affirmé à de nombreuses reprises que la nature politique d'un différend n'a aucune incidence sur le devoir de la Cour de répondre aux questions d'ordre juridique par l'Assemblée générale qui lui ont été posées. Par ailleurs, la Cour dispose d'une abondance de preuves et d'éléments factuels qui lui permettent de rendre un avis consultatif. Enfin, l'existence d'un processus de négociation ne saurait justifier l'usage par la Cour de sa discrétion de ne pas rendre cet avis consultatif. Et contrairement aux allégations de certains intervenants, l'avis de la Cour, loin de compliquer ce processus, par ailleurs au point mort, ne pourra que le renforcer en clarifiant les obligations et les conséquences juridiques pour toutes les parties. Pour conclure ma présentation, je voudrais rappeler les propos de Nelson Mandela, quelques années après la libération de l'Afrique du Sud. Il a lancé un avertissement qui nous concerne tous. Je cite, « Having achieved our own freedom, we can fall into the trap of washing our hands of difficulties that others face. Yet, we would be less than humans if we did so. » Et c'est dans cet esprit qu'il avait prononcé les mots qui continuent de résonner dans les rues du monde entier. Aujourd'hui, our freedom is incomplete without the freedom of the Palestinians. Monsieur le Président, je vous prie maintenant de bien vouloir accorder la parole à mon collègue, le professeur Mohamed Hillel. Je vous remercie pour votre aimable attention.
Je remercie Madame Geldic. I now give the floor to Mr. Mohamed Hillel. You have the floor, sir.
Thank you. Mr. President, distinguished members of the Court, it is a privilege to appear before the Court on behalf of the African Union. As indicated by the Legal Counsel of the African Union, I will cover the following issues. I will identify the internationally wrongful acts that are attributable to Israel and address the question of the legal status of Israel's occupation of the Palestinian territories. Second, I will address the question of whether there are circumstances precluding the wrongfulness of acts that are attributable to Israel. And third, I will outline the legal consequences arising out of these internationally wrongful acts. The point of departure for determining the legal status of Israel's occupation of the Palestinian territories is the question of title. Does Israel have title over the West Bank, Gaza, and East Jerusalem? The answer is unequivocally no. Given time constraints, I will only identify the main milestones of Palestine's history. Palestine was under Ottoman sovereignty, and it came under British belligerent occupation during World War I. Then, in 1922, Palestine was placed under a League of Nations mandate that provisionally recognized Palestine as an independent nation under British administration, after which Turkey renounced sovereignty over Palestine pursuant to the 1923 Treaty of Lausanne. This was followed in 1947 by the adoption of the Palestine Partition Plan, which was never implemented. And then in 1948, Britain withdrew from Palestine and Israel unilaterally declared independence, which was followed by armistice agreements in 1949 and the establishment of Egyptian control over Gaza and Jordanian control over East Jerusalem and the West Bank. And finally, in 1967, Israel launched an armed attack, as a result of which it occupied the West Bank, Gaza, and East Jerusalem. At no point in this process did Israel acquire title over these territories. Moreover, theories that support an alleged Israeli title over these territories, such as the claim that the legal status of Palestinian territories was indeterminate, or that there was a sovereign vacuum that Israel was entitled to fill, are entirely unfounded. Accordingly, since 1967, Israel has exercised belligerent occupation over the West Bank, Gaza, and East Jerusalem. The African Union also submits that Israel's 57-year occupation of the Palestinian territories is unlawful and must be brought to an end. This determination is based on three arguments. First, as the overwhelming majority of parties in these proceedings have argued, Israel's occupation is unlawful because it violates the prohibition on the acquisition of territory by force, which is a corollary of the prohibition on the use of force. This constitutes a violation of a peremptory rule of international law. The evidence on this point is incontrovertible. Pronouncements by Israel's political leaders and the conduct of Israel on the ground reflect an intention to perpetuate the occupation through acts that amount to de jure and de facto annexation of Palestinian territories. Israel's conduct in the current hostilities in Gaza also demonstrates its goal of entrenching its occupation of Gaza. Israel is reportedly planning to establish permanent buffer zones, maintain a long-term active military presence on the ground, and is striving to displace the population of Gaza to neighboring states. This conduct, which has been roundly denounced by the African Union, confirms Israel's intent to acquire and annex further Palestinian territory in Gaza. Second, also as the overwhelming majority of parties have argued, Israel's occupation is unlawful because it deprives the Palestinian people of their right to self-determination. It is uncontested that the Palestinians are a people that are entitled to exercise self-determination. It is also established that self-determination is a right that is exercised in relation to a specific territory, and that it is unlawful to disrupt the unity and integrity of the territory in relation to which the right to self-determination is exercised. In the present case, the territories on which the Palestinians are entitled to exercise self-determination are the West Bank, Gaza, and East Jerusalem, which constitute a single, indivisible territorial unit. Violating the right to self-determination also constitutes a violation of a peremptory rule of international law. Third, the cumulative effect of Israeli policies and practices that are associated with the occupation provides an additional basis on which to conclude that the occupation is, as a whole, unlawful. This is a point that deserves to be highlighted because it has been argued that violations of the law of belligerent occupation do not affect the legal status of the occupation. Specifically, the United States claimed, and I quote, that international law does not provide for an occupation itself to be rendered unlawful or void based either on its duration or on any violations of occupation law. This view is incorrect. The violations of international law committed by Israel in the occupied territories constitute continuing and composite breaches of international law. Specifically, Articles 14 and 15 of the ILC Articles on State Responsibility provide a basis for establishing that separate and distinct violations of the law of belligerent occupation can, when combined and viewed cumulatively, lead to the conclusion that the occupation as a whole is unlawful. Article 14.2 of the Articles on State Responsibility defines a continuing wrongful act as one that continues in time and remains not in conformity with an international obligation. According to the ILC, examples of a continuing wrongful act include, and I quote, the maintenance by force of colonial domination and unlawful occupation of part of the territory of another state. This confirms the relevance and applicability of this concept to the case of Palestine. Other examples of Israeli practices amounting to continuing breaches include settlements in the West Bank and East Jerusalem, the separation wall, the network of bypass roads, legislative acts purporting to annex portions of the Palestinian territories, and the exploitation of water resources in the West Bank. In addition, internationally wrongful acts that are attributable to Israel should be viewed as composite breaches of international law. As defined by Article 15 of the Articles on State Responsibility, composite acts are made up of a series of actions or omissions defined in aggregate as wrongful. This does not exclude the possibility that every single act in the series could be wrongful in accordance with another obligation. As the ILC explained, the concept of composite breaches is intended to address situations where the responsible entity, including the state, adopted a systematic policy or practice, and that is precisely why the concept of composite breaches is valuable in the present case. It captures the fact that Israel's conduct is not composed of random or isolated wrongful acts. Israel is pursuing a systematic policy that is designed to perpetuate its control of the Palestinian territories. For example, the establishment and expansion of Israeli settlements and the transfer of over 700,000 Israeli settlers to the occupied territories is wrongful under Article 49 of the Fourth Geneva Convention. Similarly, the construction of a bypass road is wrongful under Articles 46 and 52 of the 1907 Hague Regulations and Articles 49, 52, and 53 of the Fourth Geneva Convention. However, in addition to violating these specific rules of international law, the settlements, the bypass roads, and the separation wall and other practices are elements of an Israeli policy through which it is seeking to gain permanent control of the occupied territories, making it impossible to restore the status quo ante bellum. These Israeli practices, when viewed in their totality, make the occupation unlawful because they constitute composite wrongful acts that violate the prohibition on the use of force, the prohibition on the acquisition of territory by force, the prohibition on systematic racial discrimination, and the Palestinian people's inalienable right to self-determination. Mr. President, distinguished members of the Court, I will now address the question of whether there are circumstances that preclude the wrongfulness of Israel's conduct. Specifically, I will argue that Israel cannot validly invoke the right to self-determination, the right to self-defense to justify its occupation of the Palestinian territories. In this regard, the historical record is unequivocal. Israel's occupation of the Palestinian territories was a result of an act of aggression that commenced on June 5, 1967. Moreover, it should be recalled that international law does not recognize a purported right of anticipatory, preemptive, or preventive self-defense. The terms of Article 51 of the Charter are unambiguous. The right to self-defense is triggered, quote, if an armed attack occurs, end quote. Indeed, the Organization of African Unity declared on numerous occasions that Israel's use of force in 1967 amounted to an act of aggression. It should also be recalled that in the Wall opinion, the Court determined that Article 51 of the Charter has no relevance where the alleged threats invoked by Israel to justify its conduct originate from within, not from outside the occupied territories. And even if one were to assume arguendo that Israel may invoke the right to self-defense as a circumstance precluding wrongfulness, which it cannot, it is patently clear that self-defense cannot justify Israel's practices. Self-defense is a narrowly construed exception to the prohibition on the use of force. Israel's practices that are designed to perpetuate its occupation can never satisfy the requirements of necessity and proportionality. Furthermore, as several states have already affirmed in their pleadings, the exercise of self-defense can never provide a valid basis for acquiring title to territory that is occupied as a result of the exercise of the right to self-defense. Moreover, given that many of the internationally wrongful acts attributable to Israel are violations of rules of jus cogens, it is our submission that self-defense cannot be invoked in this context. Article 26 of the ILC Articles on State Responsibility, and Article 18 of the ILC Conclusions on Identification and Legal Consequences of Peremptory Norms of General International Law are clear. Quote, where the responsibility of a state for a breach of a peremptory norm is invoked, the state against which the breach is invoked cannot excuse itself from responsibility by raising any circumstance that might ordinarily preclude its wrongfulness. In short, the African Union submits that Israel cannot invoke self-defense as a circumstance precluding wrongfulness. Finally, Mr. President, distinguished members of the Court, I will turn to the question of the consequences arising from these internationally wrongful acts. The ILC Articles on State Responsibility affirm the customary principle that, quote, every internationally wrongful act entails the international responsibility of the responsible state. It is on this basis that in the Chagos opinion, after the court determined that the United Kingdom's continued administration of the Chagos archipelago constituted a wrongful act, it was held that the United Kingdom was under an obligation to bring an end to its administration of Chagos, quote, as rapidly as possible, thereby enabling Mauritius to complete the decolonization of its territory consistent with the right to self-determination. The same is required here. Israel must end its unlawful occupation of all the Palestinian territories as rapidly as possible in order to enable the Palestinian people to exercise their fundamental right of self-determination. This is the request that the majority of parties participating in these proceedings have made. The United Kingdom, however, is a notable outlier on this point. It argues that if the court were to address the status of the occupation and require Israel's withdrawal, that would undermine the Security Council's framework that is premised on reaching a two-state solution through a process of negotiations. The African Union does not agree. To condition the end of occupation on a negotiated settlement is to make the occupation permanent, given that the occupying power, Israel, refuses to negotiate on the basis of the two-state solution. And it has declared its will that it will never accept the establishment of a Palestinian state. Those states that purport to support the two-state solution ought to endorse calls for this court to unequivocally determine that Israel's occupation of the Palestinian territories is unlawful. This is especially necessary given the peremptory nature of the right to self-determination and the prohibition on the acquisition of territory by force. The modalities necessary to end the occupation as rapidly as possible could be decided under the supervision of the relevant organs of the United Nations. Israel's unlawful occupation of the Palestinian territories also gives rise to consequences for other states, including the customary legal obligations reflected in Article 41 of the Articles on State Responsibility, which are, 1, not to recognize any benefit accruing to Israel from the unlawful occupation, 2, not to lend aid or assistance to Israel that might further the occupation, and 3, to cooperate to end the unlawful occupation and to protect the right of self-determination of the Palestinian people. It is perplexing that the United States has challenged the customary status of Article 41. This long-established principle has been recognized by the court itself in the Wall Advisory Opinion and by the UN Security Council. It was even applied by the United States in 1932 in the context of the Japanese aggression against China in what was known as the Stimson Doctrine. Pursuant to this doctrine, the United States government declared that, quote, it cannot admit the legality of any situation de facto, nor does it intend to recognize any treaty or agreement that impairs the sovereignty, independence, or territorial integrity of China. The court should uphold this principle. In its written statement, the African Union offered various specific ways in which states may practically and meaningfully comply with these obligations of non-recognition, non-assistance, and cooperation. The African Union simply wishes to emphasize that occupation and self-determination cannot exist at the same place and the same time. If occupation is illegal, it must be ended to permit the recognition of self-determination. In closing, Mr. President, members of the court, the African Union reiterates its call to end Israel's occupation of the Palestinian territories. The injustice being wrought against the people of Gaza as we convene here in the Great Hall of Justice makes it imperative to end Israel's impunity and hold it accountable to the rule of law. The court of history may very well judge the credibility of international law on the basis of the outcome of these proceedings. The international community has let down the Palestinian people, but the African Union has faith that in this court, justice will prevail. The betrayal of the sacred trust that is the self-determination of the Palestinian people is an enduring injustice that pleads to be remedied. It is the only path towards ensuring a future of security, stability, peace and prosperity for the peoples of a troubled region. Thank you for your attention.
I thank the delegation of the African Union for its presentation. The court will meet again this afternoon at 3 p.m. to hear Spain, Fiji, and the Maldives. The sitting is adjourned.